Is it reversible error for a stun belt to be used on a defendant during a criminal trial without any judicial oversight or knowledge? And is it ineffective assistance of counsel to fail to inform the court of the stun belt? To find out, you have to read People versus Bradford, but it's 14 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I try to cover New York Court of Appeals cases in 5 minutes or less. This is the episode on the case of People versus Bradford. This can be found at 2023 New York Slip Opinion 03187. I'll attach a link to that decision in the description. It was published by the New York Court of Appeals on June 13th of 2023. There are two main issues in this case. The first is the use of a stun belt on a defendant during a criminal trial without judicial approval reversible error? And the second is the failure of the defense counsel to bring this to the attention of the court, ineffective assistance of counsel that would justify reversal of the conviction. To understand what's going on in this case, there's a couple of aspects of the law I want to talk about. The first is CPL, Criminal Procedure Law 440.10, sub F, which basically is 440.10 is a motion to vacate a judgment of conviction, and sub F is on the grounds that improper or prejudicial conduct occurred during the trial that, if it had appeared on the record, would have required reversal of the conviction and the judgment. That's CPL 440.10. Then there's something called Buchanan error. That's the second thing I want to talk about. Buchanan is a case from 2009. It's 13 New York 3rd 1. And it's a case from the Court of Appeals that specifically talks about stun belts. And it said that a stun belt may not be used to restrain a defendant in a criminal case in the absence of or before a judge makes specific findings that it's needed. And they specifically say that as a matter of law, this is the Buchanan rule, it is unacceptable to make a stun belt a routine part of a criminal trial or murder trial without specifically identifying the security reason involved. And the last thing you have to understand is something called the preservation doctrine. The preservation doctrine says that all objections must be preserved on the record at the trial level. You have to make the objection, you can lose, and then you have a basis to appeal. But if you don't make the objection, it's not preserved for appeal. There's a very few exceptions for the preservation doctrine. One of them is something called mode of proceedings error. A mode of proceedings error is an error that's so grievous that it impairs the integrity. That's the words they use. It impairs the integrity of the proceeding as a whole. And if it's a mode of proceedings error, it doesn't have to be preserved. And in fact, you don't even need to show prejudice. The very existence of a mode of proceedings error justifies vacating the conviction. So now let's talk about the facts. The facts are, in 2009, the defendant is being charged and tried for murder in the second degree in the 4th Department. Before trial, the sheriff's department is moving him from his cell to a counter where there's a stun belt on the counter. And the sheriff's department tells him, you are going to have to wear this stun belt during your trial. We have a button that if we press it, it will electrocute you for 8 seconds. Very painful. And they press the button and they show him. It sparks. It's very scary. And they say you have to sign this form, acknowledging that we told you about it, and then you have to wear it. He signs it. And when he sees his lawyer, he tells his lawyer, why am I have to wear this stun belt? And the lawyer says, it's a requirement. I have nothing to do with it, and I can't. There's nothing I can do about it. And the lawyer, the defense counsel, never tells the judge about it. The judge never finds out about it throughout the entire trial. During the trial, the defendant alleges in his motion, it hurt him every single day where the electrodes were piercing his skin. And also, he was afraid throughout the trial that at any point, these sheriff's deputies would press the button and he'd be electrocuted with 50 to 80,000 volts coursing through his body and him losing bodily control. Ultimately, he was convicted of murder, and he was sentenced to 23 years to life in jail. He makes a 440.10 motion after he's convicted. And he claims those two grounds. He says it was error that they put the stun belt on me without court oversight and court approval. And the second thing is my lawyer never told you about it. That's ineffective assistance of counsel. The trial judge denies both applications. The Appellate Division 4th Department agrees with the trial judge, but there's 2 dissents and it goes to the Court of Appeals. The Court of Appeals has a majority and a dissent here, and the majority says, as to the stun gun issue, it was obviously Buchanan error because they put a stun belt on him without a judge even knowing about it, let alone making specific findings that justify it. But they say it's not a mode of proceedings error, and therefore it had to be preserved. It's subject to the preservation doctrine. There was no objection made during trial. It's not preserved. It's not going to be considered. It's not a mode of proceedings error, and therefore you lose. As to the ineffective assistance of counsel claim, they say, well, maybe the lawyer had reasons why he or she didn't make that application to the court. We're going to remit it, meaning send it back to the trial court for them to have a hearing as to why the lawyer did not make this known to the judge. So that's the majority decision. It's not automatically an ineffective assistance of counsel. We have to have a hearing about it. But there's a dissent here by Judge Rivera, joined by Chief Judge Wilson. And they have two different answers. They say that the trial judge was wrong on both counts. They say the stun gun issue, it was Buchanan error. It violated People versus Buchanan. But it is a mode of proceedings error because the sheriff's office usurped the court's role. They did this without the court approval. And that is a mode of proceedings error. They would reverse it automatically. And as to the ineffective assistance of counsel claim, they say there's no reason to have a hearing. The lawyer's job is to convey to the judge the objections the defendant has. The defendant made an objection to his lawyer about it. The lawyer never conveyed it to the judge. Done. So they would reverse this for ineffective assistance of counsel and for the stun belt issue. But remember, that's the dissent. The majority here is that it's not a mode of proceedings error, and they would have a hearing on the lawyer's issue. And that's the case of People versus Bradford. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.